We all know that an attorney can never guarantee a particular result. But is there ever an instance where an attorney can guarantee you're going to get some amount of money as compensation? You want to know the answer? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. There might be one instance, only one, where an attorney might be able to get you some amount of money. So what am I talking about? So let's say this is a medical malpractice case. And now, as you go through the litigation process, you realize the defense is fighting you on every single point. They say that, hey, we didn't do anything wrong. They say, even if we did something wrong, so did you, the patient. And then they say, guess what? Even though you're claiming injuries, your injuries really are not as bad as you claim them to be. So now your case goes all the way to trial. It's taken you more than 2 years to get to trial. Is there any way to guarantee you're going to get a successful result if you go to trial? The reality is that no one can predict what will happen at trial. We can't predict it. The defense attorneys can't predict it. The judge can't predict it. So because of all that uncertainty, there are some cases where the attorneys are willing to enter into a high-low agreement. Now, what is that? A high-low agreement sets parameters about the maximum amount of money that you might be able to receive and the minimum amount of money that you will receive. So how does this work? So let's say, for example, you have significant injuries, but there's a big risk, there's a big hole in your case, and now there's the risk that you could lose at trial. Well, in order to prevent you from walking away without getting anything, now the attorneys reach an agreement that says, okay, listen, if the jury comes back with a defense verdict, meaning that you lose your case, we guarantee to give you $100,000, as an example, as the lowest amount of money. On the other hand, if the jury believes everything you have claimed, and now they feel that you are entitled to millions and millions of dollars, let's say $25 million, the defense is worried about that risk. So now they're saying, okay, how can we limit or minimize that risk? Well, they may be agreeable to say, hey, the maximum amount that we are willing to pay you is $1.5 million. And if you are okay with that, if your attorney is okay with that, so now there are definite parameters. The maximum you can get is $1.5 million. The lowest amount you can get is $100,000. So if a jury comes back with more, the maximum you'll get is that $1.5 million that you agreed on. If they throw you out of court or give you less than $100,000, you will still get that minimum of $100,000. Now you might be asking, what happens if the jury comes back with a decision that's in between those parameters, between that high-low agreement? Well, in that instance, you will get whatever it is the jury decided you are to receive. So why do I share this information with you? I share it with you just to give you an insight and an understanding into what can happen here in New York in a medical malpractice case, in an accident case, even in a wrongful death case where the attorneys and the litigants have agreed to a high-low arrangement. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.